Assalamualaikum and good morning. Are you liable for someone else's debt if you are a guarantor? A guarantor is basically someone who is responsible for a borrower's debt in the event the borrower can't pay for it. There are more than 200,000 bankrupts in Malaysia as of December 2019. A bankrupt has several disabilities which include restrictions on becoming a director of a company, owning a business, and overseas travels. These disabilities serve as a punishment for those who fail to practice sound financial management. However, some people become bankrupts through the fault of others. It is common to hear about family members and close friends become bankrupts because they become guarantors for loans out of trust. Acknowledging this problem, the Parliament amended the Bankruptcy Act and now known as the Insolvency Act. Let's see first a social guarantor. Social guarantor is defined by the Insolvency Act as a person who provides, not to make a profit, the following guarantees. Number 1, a guarantee for a loan, scholarship, or grant for educational or research purposes. Number 2, a guarantee for a hire purchase transaction of a vehicle for personal or non-business use. And number 3, a guarantee for a housing loan transaction solely for personal dwelling. Previously, the Bankruptcy Act safeguarded the social guarantors by requiring the creditors to prove to the court that he has exhausted all avenues to recover debts owed to him by the debtor. The new Insolvency Act affords the excellent protection to social guarantors, granting them blanket immunity against all bankruptcy action. Now, creditors who want to enforce the guarantee from social guarantors have to resort to other forms of debt recovery, including garnishee proceeding, judgment debtor summons, and writ of seizure and sale. Although this new law does not provide social guarantors who had already been adjudicated bankrupt, creditors cannot object to the Director General of Insolvency's issuance of certificate discharging a social guarantor from bankruptcy under Section 33 A Insolvency Act. For other guarantors, for example, a company's directors provided a personal guarantee for a loan taken by the company, the creditor has to obtain leave from court before commencing bankruptcy action. Creditors must satisfy the court that all modes of execution and enforcement have been exhausted to recover the debts from the debtor to get leave. Nonetheless, the leave requirement accorded an extra layer of protection to guarantors. Previously, creditors opted the quicker way by going after the guarantors without even initiating any action against principal debtors. With this amendment, the number of bankruptcy cases against corporate guarantors has reduced. Thank you.